We have a special testimony, an expert witness, Mira Makar, MAFCA. She has operated in the rescue market since 1982, mainly as principal with customer sites in Europe, Crow dependencies in Hong Kong. A witness to the company's investigation branch of the DTI since 2005, Mira is a maverick in sector specialization, operating systems in trust and fiduciary and private banking. Mira Makar, kindly address the court.
I think the maverick there was a typo, but it can stay. It's quite intriguing. Your Grace, Honourable Justices, Commissioners, ladies and gentlemen, I'm going to briefly say what I'm talking about, and then I'll say who I am, so that you can see that there's a little bit of a connection between the two things. I'm not an observer. I've lived through what I'm talking about. I shall be highlighting the money flow aspects of transactions involving human trafficking as presented to the Commission. So I'm not getting stuff from elsewhere. I'm picking up what is being said. And it's important that today we've had two very important pieces of intelligence. One, the life of a 20-year-old Lebanese reduced to $700, and a bonded kid at 900 rupees. That was one of the pieces of intelligence I was looking to come out at, the price. Because once it goes into money and there's parallels with financial markets, you need a common denominator. As well as the laundering of those proceeds. I shall be drawing parallels with the mature cross-border markets for financial instruments, which are mature. They've been around for quite a long time now, at least 40 years, including those involving shifting risk, converting risk, eliminating risk, and that's very often you're doing something wrong. You want to get rid of the risk of any comeback. So what you do is you take preemptive action and you protect yourself because you underwrite it by the estate of your target, as well as the rental on commission of the infrastructures of professional firms, which operate as transaction facilitators in what can be described as more complex Ponzi schemes. In other words, the people who go in first, their exit is funded by the subsequent investors. The laundering apparatus to be highlighted includes the bankruptcy courts, state registers and media, the property markets, the organs of state, as well as wealth managers, including those who operate in the fiduciary markets. My own experience includes over a decade in Coopers & Lybrand International Audit and Corporate Tax, including cross-border multinationals and specializing in financial instruments, where I did training of senior managers and partners. That was to 1994. I've got over a decade as a CEO of a main market public company, including leading the teams who designed and built the infrastructure of Abacus Global, which is the single largest offshore trust and fiduciary operator in the world. And that was to 2006. Since then, I've had over a decade witnessing to Parliament and the government on law, regulation and operations, including to the National Audit Office, live and ongoing. Much intelligence is actually restricted, but it doesn't matter. There's enough public that one can work with it. And over 3 decades of experience in instructing teams of leading counsel. I had successful media presence and coverage in the national press in 2005 and 6, and that resulted in over a decade of revenge attacks and retaliations. Very similar in concept. I guess most people would be offended when you draw a parallel with the kid who ran away from his enslavement. But the way the system is working is essentially you can be targeted and can then be locked into the justice system, and you simply cannot get away. So you do end up in circumstances where you're entrapped, enslaved, if you like, and you're constantly having to respond. And it's important to pick up that forced labour for no return, you can't get out of the system, is an important parallel. When you come to look at, we were talking about how the organs of state aren't working as one might hope them to do. City of London Police, when they see people who are being targeted for various reasons by network groups they recognise are massive and they simply can't get to grips with it, is that they actually do a suicide check on you. And because obviously they don't want you committing suicide, and then people say, well, why didn't you do anything about this? And if they can conclude that you're somebody of faith, then they will put in their books, this person is a person of faith, they will survive what's happening to them, which is an extraordinary statement, because that's how they run their operations. And when you think about it logically, people of faith who have absolute humility, like, say, very poor people, apparently poor people in Upper Egypt, who can have nothing in our terms to eat, and they have their children dying, their relatives dying, bones deteriorating and all the rest of it, and they say, I am graced. I thank God. My family are in good hands with them. And therefore the concept of wealth is turned upside down, and you've got these two totally different notions. So when you look at Justin's slide, I was very interested in his slide, because on one side he had all these boats and the yachts representing pseudo-affluence. On the other side, he had circumstances of poverty. It wasn't one of the slides of aberration, but he had kids off the cart and some on. And importantly, the ones who are on were leaning over and helping the ones who are off to come on. Now, when you look at that, I immediately say, well, the wealth is with the kids. Now, I'm not stupid, and a lot of other people aren't stupid. But if you're working in a world where you recognize that as being wealthy, and the other just an irritant which you can get rid of by understanding the perversities of the money flows, then actually you can, in a funny sort of way, become empowered. So going back to the analogy with the police, here where the police don't do their job properly, where do you end up? You end up going off to being sent to the IPCC. And who are they? They're barristers. And you end up in this complaints mechanism, and the thing gets shut down, and you're demoralized, and everything goes on. So the point that was being made earlier, I'm picking up on, which is to say, yes, there are organs of state, and yes, they get in the way, but in reality, they don't have to, because nobody said to the police, we're going to shut you out of this. It just happened to be the case in 1986. We created the CPS and took the prosecution decision away from the police. That was a man-made decision. And now we have the CPS that was running 750,000, what enormous budget that it's running, $750 million per annum. So I think my point is that the problem may not be as big as we make it. So my first big technical point is that the money flow aspects of transactions involved in human trafficking, human trafficking and financial crime not involving overt trafficking both have a financial driver or a motive. Both reduce the human to a money or a financial equivalent. And to be able to build up your model, you need to be able to have some tools to work with. Some are more organized than others, because the price of this Lebanese youngster at $20, if you buy from somewhere else, it might be a different price. You can sometimes do these deals in volumes. The bonding can be altered in different places. It may not necessarily be quite as engineered and organized, but it's there. And in the case of financial crime, it is, if you like, the money value of a person's judicial standing. What does that mean? Is that you have an identity in the court system, which is our normal apparatus, and that judicial standing has a value. For example, you might have a favourable judgment or a prospective cause of action. It's got so much value, say 5 million for the sake of argument. Up to 5 million can be realised by knocking that person out or depriving them of the benefit of that 5 million. And if you can achieve a situation of permanent alienation or alternatively bullying and abandonment. For all practical purposes, you've realised your 5 million, hey presto. A key feature of that, of course, is that human rights disappear on death. So permanent alienation and bullying to cause abandonment are manifestations of death in judicial standing. And similarly, if you're preemptively using the court, setting somebody up to knock them down, you are discrediting the witness and simultaneously burying their evidence, because the evidence gets bundled with the witness, it goes into a forum, you discredit the witness, you don't really test the evidence. Crown proceedings are thereby not pursued. Judiciary call this malicious prosecution, meaning using the criminal justice system perversely with malicious intent. And that's where you get the linkage between the civil and the criminal courts, and that's where you get the linkage between the human trafficking and the judicial equivalent in the court system. A subsidiary point is of laundering proceeds. Neither of what I've described, the overt human trafficking and the financial crime where there isn't overt movement of people, each can achieve practical pseudo-legitimacy by processes of layering and laundering or conversion. Layering means, for example, operating behind a smoke screen, such as a solicitor, such that the true identity is masked, and laundering is a transaction or an event which disguises, in effect, the true origin of the money. Money is fungible. One person's £5 is the same as another person's £5. You put it into the bank, the money disappears, and you get an IOU from the bank. And you're lucky if you see it again. It depends on whether the bank crashes or gets taken over. Layering and laundering are often seen together. It appears frequently in court, where, for example, instead of a director giving evidence on capital adequacy or compliance procedures on money laundering, there's a record of him being advised and internal advisors being advised by outside advisors. The court is effectively alienated from the truth, but in an acceptable form. And when this gets tested, for example, Judge Gleeson in the HSBC money laundering deferred prosecution agreement in the States, the judge complained that he was basically reduced to a flower pot in the courtroom. He wasn't very happy about this. And he was ready to walk off, and he was basically told, does he want to keep his job and play ball? So essentially what he said he was going to do was that he'd be letting down the system and his own position if he walked off. Therefore, he was going to stay. But what he was going to do was insisting that he had the quarterly management accounts from HSBC reporting that of their procedures and what they were doing. And that was essentially to protect him, but more importantly, to protect the court. The reality was what came in was heavily layered and heavily laundered, and the money laundering carried on, hey-ho. Secondly, the parallels with the mature cross-border markets for financial instruments. Each of the markets for human trafficking and financial exploitation not involving human trafficking create an implicit price on life. I was delighted that we had a couple of examples because that makes it more tangible. It's a working presumption, and I say that guardedly because it's not proven, that financial exploitation is more orderly insofar as there are trodden paths, trodden operators, marketed instruments, which many people are using consistently, backed by known insurance companies. So I'm making a rebuttable presumption for working purposes that those are more packaged markets, whereas the slavery one may be more disparate. That's a working presumption, so I'm just flagging that. I'm saying I don't actually know. Success is indicated by, for example, the ability to assume global financial risk, whatever it might be, wrapper it into a product, characterize it as risk mitigation, whereas in fact it's the assumption of unquantified and unquantifiable risk, not under anybody's control. And then you dump it on your customer or your target without telling them even. Sometimes you're told, but it's not described properly, like an interest rate hedging product. And so this person who's running their company and is going, for instance, and borrowing some money, they think they're borrowing and they're paying 5% or whatever it is. But in fact, they've been sold an instrument without knowing it, because the bank has gone and signed up to various deals to get the money. They never see it, and yet it's enforced against them as if they had, of their own volition, entered into that transaction. Those contraventions of human rights. Driving up, secondly, so I'm describing success. So that's a manifestation of success, that you can do that. You can target somebody and you can pull. Secondly, driving up the price of entry, because where you've got networks cooperating with each other, and they can make it harder and harder for people to come in, so smaller players can't get in, you get new barriers which are controlled by the networks, and they very often include methods of compliance that are very onerous for a smaller operator, but for a bigger one, they're actually what's called a legal obstacle and a mechanism for them to be able to get away with what they want to get away with. So that's a big hurdle for the small player. A, you've got to do all this regulation, and B, the regulation is actually perverse to help someone with a bigger transaction. So you get new barriers which are controlled by the networks, driving out the smaller players, and one of the consequences of that is that you end up with decades of inexperience. And the irony is that you have the inexperienced amongst the smaller players, but you also have the inexperienced amongst the bigger players, because the bigger players are managing these long-term relationships and these longer-term activities of which they are just a part, giving up their own autonomy and their ability to speak for themselves for the arrangement that they're signed up to. So they are becoming as de-skilled as the smaller players. It's an irony. And what this actually does is to highlight that in the case of these people who come in as receivers, liquidators, surrogates, people from social services, people from the Court of Protection, the official solicitor, the official receiver, they've got loads of names, that in point of fact, there is no proper mechanism to make Mr. A in control of Mr. B's estate. There is no proper mechanism for Mr. A having the standing of Mr. B. There is no way that somebody's personal data can be taken and used by someone else, or that control over their bank accounts or their tax files, and then ultimately giving them back the leftovers if there is any. So just as you can take over a human being's life, and I make no great difference between a child and an adult, child can often be much wiser and untarnished, you take over their judicial standing. So these are manifestations of success. Thirdly, replacing substance by process and procedure, incorporating procedure into what is regarded as law or rules, and introducing, for example, what's called a judge's ruling in place of a reasoned judgment. So the judge, rather than being an officer of the court, and his judgment is the judgment of the court, it's not that personal, actually becomes that man has said something, here's a ruling, never mind the reasons, never mind the appeal. And that's where you're able to say, if you can influence a particular person, then you can gain control over the outcome. And the big compromise is that very many judiciary have actually been seen to have entered into commercial transactions. For example, borrowing money from the banks to fund chambers. Chambers used to be individuals and you pay your way as you go along, but now they're operating as businesses and they have borrowings. And which judge is going to find a hideous ruling against Royal Bank of Scotland? No, I didn't say it, we're not being... Sorry, against a bank where the bank is somebody who's got influence. So replacing substance by process. 4, where you've got auditors who blocked communications from people who've got evidence, which they do, then one of the self-adjustment mechanisms doesn't work. And the other indicator of success is that you've got super high incomes to the operators, which is out of line by a factor of 10 compared to people in smaller organisations or in state organs. I can now say a great deal about the rental of professional services as a cover. I'm going to jump that part. Safe to say that a feature is that they are self-regulated and the infrastructure can be used, meaning as a front, and it has certain attractions galloping through them, anonymity, the Legal Services Act, which gives capacity and standing where there is no legal or natural person. 3, abandoning duty in favour of service. 4, legal professional privilege turned into a device and extended to information rather than simply proper advice from a proper person to a proper customer on a proper issue. Client monies, outside the scope of audits, but you get a certificate instead. Can be used to launder bribes, we've seen, and can be used to take somebody's money so that they're basically suppressed and you don't give it back. Legitimising offences by circumventing the law by complaints mechanisms and through regulatory bodies. Use of professional indemnity insurance to give a veneer of professionalism, whereas in fact you're invested in instruments of fraud and dishonesty. Access to a plethora of people, private investigators, insolvency practitioners, locksmiths, bailiffs, etc., and laundering through Parliament, because very often the law doesn't actually work if it depends on rules which never appear. That applies to the Insolvency Act 1985, no rules, it's not operational. And then control and influence over the prosecutors and their supply chain, because they are basically the operators of the scheme have that degree of control. So that was how you can get a strong position and maintain it and drive other people out, but inside it you're missing experience. So it's self-destruct. Facilitation, I've already said about the Ponzi schemes, transactions involving risk transfer, conversion and elimination. A Ponzi scheme, because the people who've gone in at the beginning, they get out as more come in. There is no judicial mechanism for curtailment. The schemes have not been heard in the UK court, and indeed nor has anonymity. Next section is that the laundering schemes, there's a plethora, and they also include disabling checks and balances. The most obvious are the bankruptcy courts, state registers, media, websites and subscription services. The organs of state include the courts, especially the family courts and the Court of Protection, and finally wealth managers, including financial operations. My conclusions. Each time there's a perversity on a register in the court, the converse, a relief, is automatically triggered and accrues to the person harmed. This on the surface suggests that the system is self-adjusting. The target, who may be the subject of bullying, for example, to cause them to abandon their standing and estate, automatically acquires a valid cause of action. In practice, the apparatus or organ of state are not geared up to perversity or the contamination of the law enforcement by policy. So you have law enforcement, it gets contaminated by policy. Policy comes in through procedures. The two coexist. Operations go according to policy and not the law enforcement. So there is no trodden path for unscrambling that. Essential repair is by addressing the facilitating devices. Ultimately, they don't work because a price cannot be put on human life. Recognition that the biggest advantage of Crown proceedings is not the value recovered, but curtailment of the wrongdoing, stopping somebody. Tackling anonymity at the front door of the courts, including funding, secret funding as well, as a precursor to crossing the threshold of the court. Who are you? A first authority that value creation by bringing down judicial standing is a perversity and contempt of court. Contempt of court, by the way, is a recognised omission from the civil procedure rules. a bit of a problem, a blitch or a glitch, I think Justice Warby calls it a glitch. Dealing with trading in personal data, including professional firms operating schemes of sweating the assets, customers and targets, and somebody's information, sweating the asset. Like it's a term that's been pinched from the telecoms industry. That's to say the information of clients and targets to fuel long-term networks and alignments, and registers with integrity which do not separate lawyers. With the land registry, a lawyer doesn't have to produce evidence, whereas landowners do, backing your documents. So our registers are contaminated. So until the repair happens in practice, there is an anonymized lock-in of the targets in the court. You're stuck, you're sitting there, whose identity and property is taken and used. This includes in out-of-court contracts that you don't know anything about. The expenses are underwritten by the target's estate, and there is no mechanism to get out. The conditions of slavery, servitude, and forced labour for no pay thereby continue indefinitely.
Bravo. Very good. Very good.
That's been very, very helpful indeed. As I understand it, what you were doing there was to break down what happens with the money and the money flow.
Beyond that, making a parallel between trading in human life and saying that in a court system, which is what the world is based on, a court system, the law, parliament and the courts, you've got something called judicial standing, and that's got a price tag. And in the slavery business, where people are physically moved, they're enticed to move or they're required to move, you've got a price tag. And it's the price and the standing of the human being that you've got the parallel. So it's reducing the human to a money amount.
Exactly. So in both cases, although not totally correlated, there are examples of valuing a human being, the life of a human being. Or are you saying that there is a correlation?
To make it work, to make the parallel work, the slave business puts a price on the human. And in the financial markets, there's a price on the human. And the apparatus is the common apparatus. And the challenge was that humility, when apparent poverty, is actually can be valued. If you wanted to break this horrible system, you can say there's value. Whereas the money value, the yachts and things, you can just knock them down.
Let me add up, or let me summarize 4 hours of witness debriefing prior to this. I've learned a great deal. There is a machine that treats children and people of wealth who are not part of the Rothschild system as prey. And they monetize the children, and they monetize the estates, and they strip both. We have digital murder going on in the system that we call the financial and court system.
Okay, so just getting some clarity in there, and thanks for the polemic as well. I think what's key in this is that in drawing the parallels between the two, obviously there's distinct incidences, such as in America, where there's a court system that actually increases the amount of people who are arrested and committed to prison, and actually does send them off to prisons that are actually owned by judges, which is obviously a very distinct example of what we're talking about. And then there's the example also of the fact that actually humans who are indentured or put into bondage have a value above and beyond what we're discussing today, which is obviously merely the need to traffic them and merely the need for the sex abuse issues as well. So I think what would be very helpful in this instance is to really explain, because you clearly have that expert knowledge, is to also explain how the money actually flows, if you can assist the court with that. So not just merely the correlation that there are similarities between the two propositions, but also there seems to be a very clear, from what you're saying, a very clear point that you wish to make, which is to say that that those people who are put into bondage are sold, that there's money involved in it, and to explain where that money goes and who funds that.
The answer to that is trivial.
Yeah,
it can be done.
Yeah.
You wouldn't try and do it in generic terms, but you do it by way of an illustrated example. So, for example, there's an unregulated collective investment scheme operating in something which is called insolvency, which doesn't actually exist. And the ownership is secret through Guernsey, and it's unregulated, so nobody knows the far end of it. And the individuals who are running, who are the bonded individuals, they are allowed to, if they buy an instrument that pays out on their fraud and dishonesty with the collusion of others or others with their connivance, and they're registered with the government and they don't have to bother registering for VAT, and they've got one of these instruments, then they can go against an individual and nobody's going to touch them.
Very good. So, in the example that you've just given there, that's very, very helpful to the court. I just want to push you a little bit further on that, because clarity is often needed for the lay people who have been listening in as well. For example, the example that may exist in, say, a country such as Malawi, where there's clearly huge tobacco businesses involved. They're multinationals. They're owned by some of the people that the council may refer to from time to time. Those people who are held in bondage there, who work the fields for zero pay, produce 1 in 4 of the cigarettes that people smoke throughout the world, and create some of the biggest companies in the world. How is it that we, in this country, who have those companies listed on our stock exchange, seem to be unaware of it?
We're not unaware of it. You'll find that the auditor of, I'm not going to name names, but BAT or somebody, is going to be somebody who works in one of these networked operations. They're limited liability partnerships. They're called alternative business structures, which have this capacity offshore to pull down people who object and complain. And the audit certificate has now become reduced to an instrument itself, but what we used to have before was a proper audit. We don't anymore. And that the person who's sitting there is operating this scheme where the certificate is just sitting there and there's no audit, and then they come out and they become the chairman, continuing to operate. And you can see the manifestation of that is the amount of money that people earn as an auditor, starting at £500,000 going up to X million. That's the indicator of the wealth. And then you go right down the chain and you see how it happens. And the same happens with drugs, because drugs which are bought by the UN for this country, for this country, for this country, and are subsidised, they go round in a circle picking up all the subsidies.
Let me ask you to please make the point about how we don't do true cost economics, and the cost of all of these people working for free is not, if I understood you correctly, articulate how the cost of all these people working for free is not factored into the audit and therefore is not made known to the British people.
The auditors don't actually turn up on site very much these days. And that came out in the HBOS trial in Southwark at the beginning of this year, at the end of last year and the beginning, oh goodness, the years have gone by. The end of 16 and the start of 17, there was a 12-week trial of the 8 people who went to prison from Bank of Scotland. And there was a lot of cross-examination of people who described KPMG. And KPMG, they basically said they were just sending minions. Nobody was taking evidence from internal audit. Nobody was taking evidence from the managers. So they're actually physically not turning up. It's a political negotiation at the upper echelons. So the accounts are fundamentally made up.
And so you say that negligence is...
It's not negligence, it's knowing.
Very helpful, thank you.
But let me ask you to articulate...
I would say reckless, but it's not, it's knowing. So just to be precise.
If I understood you correctly, there is no economy of harm in situations where there's no one individual, but there are millions of individuals. Could you articulate whether there is any economic calculation of the damages done to multiple individuals?
Well, when you've got everything going into a market up at the top, then that's going to drop out of the equation.
Very helpful.
So when you have, for instance, G4S and their aberrations and running the prison services, etc., you have to look back at G4S. It was the combination of two companies, which included security companies with massive risks. They had a consolidation in the 18 months to the 31st of December 2004, and then an AGM in June 2005. The so-called joint auditors, PwC and Baker Tilly, for the first 18 months, PwC resigned on the 15th of January 2005, leaving Baker Tilly. Baker Tilly had been booted out of the Institute of Chartered Accountants and debarred from audit, so there was no auditor. And the accounts, so-called accounts, were adopted on the 30th of June 2005 in an AGM, because now adoption by shareholders is being used as a surrogate for proper accounts, so it's blind. And on the 31st of July 2005, KPMG comes in as a brand new auditor, having adopted this thing, and inside this thing was 700 million of unexplained debt and loads of, this is our opinion, that's our opinion. So
I'm going to need to move on. Chief Justice, would you like to say a few words?
Just a very quick question. If financially you want to destroy somebody, is not the process to do it through the civil procedure rather than the criminal procedure? Because then you can adopt a much lower standard of proof against the person, and if the victim actually wins at first instance, you then lodge an appeal and you keep running it through until the person runs out of money or runs out of friends. I have a friend who blew the whistle at a particular firm where they were destroying evidence, and civil proceedings were taken against him, and he's been made almost penniless as a result of it. Whereas if they use the criminal procedure, you then have the right of trial by jury. You've got all the protections of the criminal procedure. So if you're going to do something, if someone, for example, steals from you and you want to destroy that person, you don't charge the person with a criminal offence. You charge them with a civil claim, and you run it through until they either die or they run out of money and commit suicide.
okay, let me get your people right. So you're trying to destroy a wrongdoer, or you're trying to destroy the whistleblower?
To destroy an innocent man.
So shall we say like the whistleblower?
Yes.
Yeah, if you want to destroy a whistleblower, you want to destroy the whistleblower. Why? Because they have the evidence that's going to get you into the Crown Courts.
That's right, yes.
So that's what you do. You put them in, you nail them in the civil courts, but what you do is you make a claim which has no substance to it.
Yes.
You nail them as a defendant. You don't say who you are. You use a logo, and you rely on the systems, because in the court, the computer system will pick up a monetary amount. So even though if you read the claim form, it's got no substance, you're stuck in the court because it says that you're defending a £10,000 claim or whatever. You're nailed, but the person never says who they are. And in the background, they've written a contract which says it's worth so much to get rid of this person, and we're going to underwrite it by their unfettered assets. They can't get out.
Chief Justice, we'll be covering this in the special session on Wednesday, but the witness has provided 3 documents that are essentially falsified court documents that she has very ably annotated, showing the falsification at each level in each document. The system is complicit because everybody processing these documents knows that they are false documents, that there is no substance in the document, and yet they are not only processing these documents, they're doing it in a way that obscures and prevents the public from seeing the falsity of the documents.
The person processing the documents is picking up a salary, often paid for by the state, and knows if they do it for long enough, they can retire and get a pension.
Are the power behind the ITNJ. Add your voice. Sign the treaty.